Marcus gets pulled over on the 101 in Santa Clara County. 4th DUI in 8 years. He's been through this before and assumes it will play out the same way. Then his attorney calls and says the DA is filing felony charges. That one word changes everything. If you're facing a felony DUI in California, the consequences are in a completely different category. I'm Nana Knight. I'm a criminal defense attorney in San Jose, and in this video, I will cover the 4 situations that turn a DUI into a felony, the real penalties, and a doctrine called the Watson murder that most people have never heard of until it's too late. Most DUIs in California start and end as misdemeanors. A first, second, or third DUI conviction under Vehicle Code Section 23-152 is typically a misdemeanor. The penalties increase with each conviction, but the classification stays the same. You're looking at county jail time, some fines, DUI school, and a license suspension. Serious but manageable in the sense that the case stays in misdemeanor court. There are 4 specific situations, however, where that changes. 4 circumstances where the charge moves up from a misdemeanor to a felony. Understanding those situations tells you what you're actually facing and what you can expect. Situation number 1, your 4th DUI within 10 years. Under Vehicle Code Section 23550, a 4th DUI conviction within 10-year period can be charged as a felony in California. The 10-year window looks back from the date of the current arrest and counts prior DUI convictions and a reckless convictions on your record. I want to be precise about something here, okay? This charge is a wobbler under California law. That means the district attorney does have discretion to file it as a misdemeanor or as a felony. And in Santa Clara County, prosecutors frequently choose the felony path, especially when there are aggravating factors present or high blood alcohol levels or prior accident or a pattern of non-compliance with DUI conditions or a violation of terms on a prior DUI probation. As a felony under Vehicle Code Section 23550, you're looking at up to 3 years in state prison, a 4-year driver's license revocation, and a 30-month DUI program and fines. You also permanently lose the right to own or possess a firearm. That consequence does not expire when your sentence ends because now you have a felony on your record, right? And felons are prohibited from carrying weapons in California. Situation number 2, DUI with injury. Vehicle Code Section 23153 covers a DUI where the driver causes bodily injury to another person. This is also a wobbler. As a misdemeanor, the conviction can carry up to 1 year in county jail. As a felony, the base sentencing range for first felony DUI with injury is 16 months, 2 years, or 3 years in state prison, so up to 3 years. With prior DUI convictions, that range increases. So 2 prior DUI convictions within 10 years and a felony DUI with injury can result in a sentence of 2, 3, or 4 years in state prison on the base charge alone. Enhancement allegations for each additional injured victim can also add more time on top of that. People are often surprised by how low the bar is for bodily injury under the statute. Courts have found that relatively minor physical harm can qualify for this. A sprained wrist, for example, or sore neck or sore back, bruising. The injury does not have to put someone in the hospital for the charge to apply or for the enhancements to apply. Situation number 3 involves a situation where there's a prior felony DUI on your record. Vehicle Code Section 23550.5. This section applies when someone is convicted of a new DUI while having a prior felony DUI on their record within 10 years. So the second felony, right? Even if the new offense would otherwise be a misdemeanor, the prior felony conviction changes how it's classified and how it is charged. This situation catches people off guard more than any other, right? So they served their time, they completed their terms, they assumed the prior case was closed. But a prior felony DUI does not just affect future charges. It also follows the interaction with the criminal justice system in ways that are hard to fully anticipate until you are unfortunately sitting across from a prosecutor. Situation number 4, DUI causing death. This is the most serious category and the one where 2 separate charge paths exist. 2 separate charging options for the prosecutor. The first is gross vehicular manslaughter while intoxicated under Penal Code Section 191.5a, and this applies when a DUI driver causes the death of another person gross negligence. It is a straight felony that carries up to 4, 6, or 10 years in state prison. and that's a significant sentence. The second is second-degree murder under Penal Code Section 187. This is known as Watson murder, and I want to spend some time on this because it is a legal doctrine that changes the stakes in a way most people do not understand until it's too late. Now, the Watson murder doctrine. In 1981, the California Supreme Court decided a case called People versus Watson. The court held that a drunk driving death can be charged and prosecuted as a second-degree murder where the prosecution can prove that the defendant acted with implied malice, specifically a conscious disregard for the safety of others. The mechanism that makes the doctrine work in practice is something called the Watson advisement. When you're convicted of a DUI in California, the court is supposed to give you a specific written warning at sentencing. The Watson advisement states, and I'm quoting the substance of it, that you understand that driving under the influence of alcohol or drugs is dangerous to human life, that you understand that danger personally, and that if you drive drunk in the future and someone dies, you could be charged with murder. This is the gist of that advisement. You sign that document and it becomes part of your court record. In a future case where someone dies, the prosecution can go pull those records, pull the minute orders, or prove that you were advised of the Watson advisement in court and presents that signed advisement as evidence of implied malice. Their argument is direct. You were warned. You knew the danger. You drove drunk anyway. And that's not an accident. That is conscious disregard for human life. And under California law, conscious disregard for human life is the definition of implied malice, which is the legal standard for second-degree murder. A Watson murder conviction under Penal Code Section 187 carries 15 years to life in state prison. So a standard DUI becomes a murder case, and that is what the Watson doctrine does, right? If you or someone you know received a Watson advisement after a prior DUI conviction, drop a comment below and tell me what county that was in. I want to know how these advisements are being delivered across the Bay Area or other parts of California. Professional license consequences. A felony DUI conviction does not stop with the criminal case. In California, professional licensing boards operate independently, and they have their own authority to investigate and impose disciplinary measures such as license suspensions on individuals who are convicted of serious offenses. For healthcare workers regulated by the Medical Board of California or the Board of Pharmacy, a felony DUI conviction can trigger license suspension or revocation proceedings. So real life-changing consequences that can affect your livelihood, your ability to make a living. The board does not wait for the criminal case to conclude. An arrest alone can be enough to open an independent investigation. For educators, a felony DUI conviction triggers mandatory review by the California Commission on Teacher Credentialing. A credential can be suspended during the investigation. And for attorneys, a felony conviction in California results in automatic disbarment. There's no discretion. The conviction can trigger this, right? For Bay Area tech workers, the analysis is more fact-specific. If your role involves a federal security clearance, access to sensitive systems, or employment with a contractor that runs regular background checks, a felony conviction can put that employment at risk, depending on the terms of the clearance or the contract. The point is that the criminal case is the beginning of the consequences, not the end. There could be many collateral consequences. Another consequence is immigration consequences. If you're not a United States citizen, a felony DUI conviction requires a separate and careful immigration analysis. A standard misdemeanor DUI under Vehicle Code Section 23152 has historically not been classified as a crime involving moral turpitude under federal immigration law, and courts have repeatedly held that a basic alcohol DUI does not trigger removal on its own. But a felony DUI charge, that changes the risk profile in several ways. The severity of the offense, the length of the sentence, and the facts of the case all factor into how immigration authorities evaluate your felony conviction. A felony DUI with injury or DUI causing death could trigger scrutiny that a misdemeanor would typically not. A DUI involving a controlled substance is an entirely different matter. Under federal immigration law, convictions related to controlled substances are treated much more harshly. A drug-related DUI can be a deportable offense, regardless of whether California classified it as a misdemeanor. For H-1B and other non-immigrant visa holders, even a misdemeanor DUI, driving under the influence of drugs, can affect visa renewal and re-entry depending on the circumstances. So it's really important to consult with an immigration immigration attorney. A felony DUI significantly increases that risk. A pending immigration application, a pending green card, or a naturalization petition can all be jeopardized by a serious criminal conviction. The critical point here is this: if immigration status is a factor in your situation, you need both a criminal defense attorney and you also need a seasoned immigration attorney who is involved from the beginning. Resolving the criminal case without understanding the immigration consequences is a mistake that cannot always be undone. Okay, so it's really important to get an immigration attorney involved if you are facing immigration consequences. Now, let's talk about what to do if you're facing any of these charges. The most important thing I can tell you is this: the charging decision happens pretty early on. Whether the DA files a misdemeanor or a felony, whether they pursue a Watson murder theory, whether they bring enhancement allegations, all of that happens in the first weeks after your arrest, when your police report documenting the incident and the DUI arrest is turned over to the prosecutor's office for their review and filing. The time to get an attorney involved is not the day before or the morning of your arraignment. It is the day you are arrested or the day you find out that you are under investigation. The earlier an attorney can analyze the facts, talk to the prosecutor, and start shaping how this case is built, shaping the narrative, the more options can potentially exist for you in your situation. And if you're facing a fourth DUI or a DUI with injury or a case involving death, do not navigate it without experienced criminal defense counsel. And before you do anything else, watch my video on what to say when cops try to trick you during a DUI stop. It is on this channel and it is directly relevant to protecting yourself from the moment a stop begins. If you're facing DUI charges in San Jose or anywhere else in Santa Clara County, including North County and South County, call Nightlaw at 408-877-6177 and drop a comment below. And have you or someone you know ever received a Watson advisement after a prior DUI conviction? I'm really interested and curious to find out.